All right, let's do this. So we've got two members that are still in Baltimore City delegation right now, but we can get started on some of the less controversial bills here. So let's start off with, all right, so did we say that 201 is going to be held for amendments, Senator Wallstreicher? You worked it out, but it's,
yeah.
Okay.
Yeah. Just for the record, so for Senate Bill 201, thank you to Senator Patterson, thank you to Senator Castley, and Senator Sidnor. We've worked everything out. The amendments are forthcoming, and if we could vote on this early next week, please.
All right, excellent. Let's go down to, Senator Huff, did you talk to the folks for Feldman's bill for the?
Yes.
Okay, let's do that. Who's the council? Who's council?
Or 726.
No.
280?
No. 726.
Okay.
Is that Josh? Yeah. Can we just give a recap and then we'll?
This bill authorizes a personal delivery device to operate without registration on any highway, sidewalk, or crosswalk in the state. The bill excludes such devices from the definitions of motor vehicle and vehicle and establishes various other standards and requirements that must be adhered to by devices operating pursuant to the bill's authorization. There is an amendment in your packet. It's a rather substantial amendment. It's number 993126/1. It does a number of things. Mr. Chairman, would you like me to go through and read all of them again, or?
Just the wave tops.
Yeah, I mean, it allows these devices to operate on footpaths and bike trails. It kind of clarifies the insurance requirements, increases the max weight of these devices, increases the maximum speed that they can operate to 10 miles per hour, requires them to obey traffic signals, requires them to coordinate a little bit with MVA on emergency response plans, requires them to inform counties and municipalities before they begin operating in those areas. And it creates a permitting process that will be in effect from at least October 1st, 2021, that the MVA will operate to authorize these vehicles to operate until the substantive provisions of the bill come into effect, which the amendments move back to July 1st, 2022.
So I reached out after the voting session and talked to FedEx about the bill. I talked about some of the concerns that people brought up. On the 10 mile an hour, they said that essentially almost every state that does this has the maximum speed of 10 miles an hour or more. Some of them have 12 miles an hour. And that's only a maximum speed. That doesn't mean these things will be going around at 10 miles an hour, but if there's an open, like, middle of nowhere part, that's when they would do the 10. But, to address the committee's concerns, they were willing to go down to 7. So I would offer we could do 7 miles an hour. Anything below that really just puts us out of the realm of where the other states that have this, and it's, this is going to be across the whole country, eastern seaboard of Amazon and FedEx using this technology. And then the last concern that Senator Castley had about municipalities, the problem is if we allow, I don't know how many local governments there are. I mean, in my county, you've got the county, then the municipalities, you're looking at a dozen right there. I mean, you're probably looking at over 100. So if Amazon or FedEx, whoever, has to go and negotiate with 110 different municipalities, that's just not going to work. So that's why we need a statewide standard. So I would suggest we put it at 7 miles per hour and move it forward. And and one last thing, I'm sorry, and that's a maximum speed too, so everyone understands. It doesn't mean the thing's going to be driving around 7 miles an hour all the time.
Senator Jackson, Senator Lee.
Thank you, Mr. Chairman. Thank you for the amendment, Senator Huff. Look, I did a little research myself, understanding, it's not a human being, it's a machine that stops on a dime, but I do appreciate the 7 mile an hour change, and I'm in support of the bill. I'll support the amendment as well. So.
Michael, maybe you can ask, did you ask them if there's a distinction between that maximum speed limit for a sidewalk versus like a roadway? Or is it applied to both?
No, I didn't ask. It's just what the machines are engineered to be. So I thought after
I think there's a difference between being on a sidewalk than being on a roadway.
Yeah, and
Senator Jackson had pointed that out, and
yeah,
Senator Stignor too.
it's just so what the law would say is that's the maximum they could go. I mean, look, to be honest, I thought that was a pretty a good concession. Anything lower than that, I said most states are already 10 or 12 miles an hour, so we'd be already lower than most. So, and then, like I said, it's a maximum speed, so it doesn't mean they're going 7 miles an hour down the sidewalk. It's supposed to be 7 really if it's like an empty alleyway or something where it's going to accelerate more, but it's not for this. My understanding of it from when it's on a sidewalk or something with pedestrians, it's going to be going much slower.
Oh, okay. Well, I'm just asking, I think there is a difference, but I guess it's at the discretion, I guess. It's a max, right? 7 is a max. And, I mean, I want this to pass, but I also want it to be safe. And also, you want to avoid, lawsuits later, civil lawsuits if something horrible happens. Anyway. Okay, thank you for looking into that.
I think the 7 miles an hour is a fair compromise. I'm looking at the bill. I guess it's an amendment to the bill that specifically says that the company that uses these things must be covered by an insurance policy that provides general liability coverage at least $100,000. That's fine. I'm worried about them running into someone, and I would think $100,000 should cover that.
So you talked about allowing council about using these on bike paths. Where is that? I'm not seeing that word in the amendment. Where am I missing?
I see it on the first page, footpath, bicycle trail.
Well, the first page is the
First page of the
introductory.
amendment, of the rewrite, of the reprint. It says authorizing motor MVA to accept other forms of security in place of insurance requirements, authorizing personal delivery to operate on any highway, sidewalk, footpath, bicycle trail, or crosswalk in the state.
Okay.
It's, if you go to the bottom of page 1 of the amendments, it's, unless the administration or local government specifically approves
Yeah,
others.
I see it. I see it now. Thank you.
Right, footpaths and bicycle paths may be
Yeah.
used by, and then
Okay,
it's a
so-
list.
So here's my concern is that we're putting these in the line with wheelchairs, mobility devices. This is commercial delivery. I don't see, they're not going to put out one of these. They're going to be hundreds of these and thousands going around the communities. And if the local community, what this says is you got to accept these just as though it was a person. You can't restrict where different people can go. You can't say, well, some people can go on this sidewalk and some can't. You can say bicycles can't, but you can't say these delivery devices can't. You have no ability to restrict that. And what I envision is you get linear trails crossing the county for pedestrian use. Most of our counties have those, and you can get pretty far on these linear trails. So the delivery people, my concern is what I see is them pulling up to the head of the trail with a tractor trailer and unloading, 200 or 300 of these things, and they all take off down the trail. And the local government has no ability, the county has no ability to control that. They have a state right to go anywhere. And even in, you have certain sidewalks in front of like a hospital that might be very crowded, and they don't want to be putting this extra commercial delivery traffic on the sidewalk. They'd have no ability to restrict that. So I appreciate their desire for a quick, cheap fix, but honestly, I disagree that this would impose unreasonable burdens because they're all going to be operating basically on the same software as Google Maps. And Google Maps can very quickly say, this route is off, this route is on. They computerize that stuff. They're able to do it all the time. They can tell you which streets are closed for the day. And these things will have that kind of GPS monitoring in them. They can very easily accommodate local interests that say, none of these things on this piece of sidewalk, go to the next block over and use that as your through street. So I just can't support something that, is putting this commercial traffic on these arteries that were specifically designed for non-commercial traffic without any local input. Thank you.
Like I said, I mean, there's no way to, if we allow all the municipalities to set up their own rules or regulations on this, then it sort of undoes the bill. Because they're looking for a statewide standard to do with this. I know it's a new technology and it's different, and there might be some fears about it, but I think it is the way of the future. I think it's very innovative. And so I think that's why I don't want to, if we don't do that, we're going to force them to go back to 110 different whatever municipalities, and then they just won't do it. So we'll be this weird outlier of all the states on the East Coast. We're already down to 7 miles an hour because of the concerns of the committee. Everyone else was at 10, so I think I'd rather just move the bill forward. I would make a motion to, how about adopt the amendment? And then once we adopt the amendment, we can make it at 7. So I'd make a motion to adopt the amendment. And then I'll make a motion that we amend the amendment to go from 10 miles an hour maximum to 7 miles per hour.
Second. Everyone good with that? All right.
And then I'll make a favorable on the bill as amended.
Second. All right, let's do a roll call for that one. I'll catch them up real quick.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
I think you're grossly overstating the impact that local input would have on these devices, and I think it's unnecessary not to allow them to have local input or local control. Local control applies to trucks and bicycles and cars. They can restrict all of those, and this will be an exception to all of those. I vote no.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
Bill passes.
All right, let's go on to. Can we go to Senator Beidel's bill? That's Senate Bill 488.
Senate Bill 488. This bill changes references in marriage licenses of husband and wife to Party 1 and Party 2. It also authorizes a clerk to keep certain information as an electronic record instead of a marriage license book.
Which bill are we on? I'm sorry, I missed it. Yeah, I mean, look, I'm very much against this one. We have all these bills that address the issue of are marriages forced? Are they compelled? Are people truly voluntary? Hopefully, you're not getting. Which one is this? This is the, okay, I'm sorry. This is 488, the other marriage bill.
Yeah, sorry.
I'm sorry.
Just even, I took a look at my own marriage license, and it doesn't have, it just says it has my name. It doesn't have any other assignment. There's no like, husband, wife, any other designator. It just has my
Yeah,
name.
so the code requires it to state here the name of intended husband and to use a format that's substantially similar. But it appears as though certain counties are not following this explicitly, so this just brings the code in line with practice in those counties.
Substantially similar language, even after we amend this, or is that?
Yeah, so that remains there. So the only thing that this is changing.
We don't have to say party. They could say spouse 1 or spouse 2 or something like that.
Yeah, they could.
Party just seems so
or
cold.
leave it blank. Yeah.
My license here I got married in Anne Arundel, like it was silent. So
I'm sorry,
it just had my name. It didn't
Yeah.
even say husband, wife. It didn't.
Right.
It's just, yeah.
Yeah. Party 1, party 2. I mean, I realize it's a marriage contract, but It does. It does. You don't have to make it so so cold. So okay, I don't have any problem with this.
All right, great. So bill passes unanimously, right? Just do one more easy one. Edgar's 474. Senate Bill 474.
So this bill does not have any amendments. This bill requires a mobile home park owner to provide specified notice of the sale of a mobile home park no less than 30 days before the date of the sale, rather than within 5 days after entering into the contract for the sale.
There's been a motion for favorable, seconded. Is everyone okay? Everyone knows it does. All right. Great. Let's go on to, this is for Heather again, Senate Bill 698. Just grab her.
So with 698, there are 2 amendments in your packet. So this bill is a task force bill. It establishes the real property transfer on death deed task force. The task force must study or other jurisdictions that have implemented the use of a transfer on death deed for real property and consult with relevant experts to evaluate the potential benefits and negative implications of such an instrument and means of property transfer in Maryland. The task force must also make recommendations regarding the implementation of a transfer on death deed in Maryland. So the Attorney General or the Attorney General's designee serves as chair of the task force, and the OAG must provide staff. So the 2 amendments that are in your packet, they alter the membership. So amendment ending in 653128 adds 1 representative of the credit union industry. And the other amendment, 843825, adds the Commissioner of Financial Regulation or the Commissioner's designee.
Give folks a second to read. Questions, comments? Is there a motion for the amendment to adopt the amendment? Seconded. Is everyone okay doing that? All right. Further discussion?
Favorable.
Is a motion for a favorable? Seconded. Is everyone okay? Favorable with amendments. All right. Good. So, Jamie, I'm going to go to Senate Bill 280.
Senate Bill 280 requires the Washington Metropolitan Area Transit Authority, or WMATA, to establish a police complaints board to review complaints filed against the Metro Transit Police. The bill also prohibits WMATA from using enforcement quotas to evaluate, incentivize, or discipline Metro Transit Police members, including with regard to the number of arrests made or citations or warnings issued. The bill is contingent on similar acts being enacted by Virginia and D.C. This alters provisions of state law that are interstate compacts. So the language in the bill may not look quite like the typical drafting that Maryland uses, but that's to ensure that it conforms to the interstate compacts.
So purposely separated this out just from our police reform discussions because I didn't want the 2 things to get conflated with review boards and kind of setting up so just purposely separated this by a week or two. Senator Cashley, go ahead, and then I'll explain my support
Okay,
for the bill.
so my concern is that if we compare and contrast this legislation with the processes that this committee and the Senate approved for similar issues, it gives these folks much less due process protections and rights. And it seems to me that we should not be agreeing to a process that provides officers with less protections and rights just because they're part of the Metro Transit when they're basically Maryland police officers than we would have allowed for our own state police and local. So that's why I think the bill's premature, honestly, because we ought to see where we go finally on our local police, but then these guys ought to get, and gals ought to get the same level of due process protections, and I don't see that in this bill. Thank you.
Agree wholeheartedly with this. I know several officers that work for this department. I knew their chief, and the situation is they are Maryland police officers. They are covered underneath our training and our standards to be able to work in Maryland. They should have the exact same standards that we work so long to put forward. And this would set up a different issue. It'd be my opinion that we should hold this and set them to the same standard that every other police officer in Maryland would be held to. That's what the whole purpose of what we were doing, was setting everything to one standard.
Make a motion to hold the bill.
Yeah, just no, go ahead, and then I want to just add some clarity too as well, but go ahead.
So just a quick question before we hold. I'm sorry, who's counsel to this? All right. So we know all three compact jurisdictions need to pass this in order for it to go into effect. I know D.C. has passed it. Virginia has adjourned sine die. Did they pass this legislation?
I'm not sure, Senator, but I can look that up before the end of the voting session for you.
Okay.
Or before the end of this bill. Yeah, I'll look that up.
Thanks.
Yeah, those questions basically cleared up. It's a different entity. I mean, it's a part of. It's weird because it's not like a different county or a different jurisdiction. It's a different entity altogether, and so that's why I was comfortable with the bill. But if you want to hold for clarity to see if Virginia's moved on it, you want to hold until when?
Actually, so I think because, that agency is so unique that agency has to go through, their academy has to incorporate the guidelines or standards of training that all three jurisdictions hold. So I think, and I understand whenever something occurs, the three jurisdictions have to concur with it. I think the challenge is, we really can't sit here and do a statewide police reform and then have an agency that has to adhere to our standards to not fall under that. So, I mean, I don't know a deadline on when we do that. I mean, I guess until we get the resolution on what we're doing. So, until the resolution comes forth on what we're doing with police reform, after you all do your conference committee or whatever that may be. So, what do we do?
Yeah, I know. I mean, I guess for me, the line of thought was, I know that the House just passed their bill, but it's almost just two separate conversations because you've got one city in two states operating under a compact. It's just different. It's a different regime and scheme. So
those officers are going to be required to adhere to the laws of Maryland when they're in Maryland, and we're setting that. We've reassessed that, and we've set forth, and I think. I just think we need to be responsible, and I think we shouldn't move this bill until we have some resolution on what we're doing in Maryland.
So this is, I think what Senator Jackson was saying is very important. When those officers are in Maryland's jurisdiction, they have to abide by all of Maryland laws. They do not abide by Virginia or DC laws when they're in Maryland. Very important. What they are trained for in DC, what they're trained for in the state of Virginia does not apply to the way they enforce the law in Virginia, in Maryland, where each state, each jurisdiction is completely different and their response is different. So I think it is important that we look at this bill. This is what the parts of this are Maryland, what we're holding all other officers to.
Well, we got two senators want to hold the bill, and one wants to hold it to sine die. So we'll hold the bill We'll get some greater clarity. All right. All right. Senator Waldstreicher with Senate Bill 327. Is that ready?
Thanks. These aren't all the amendments.
I had the two amendments.
Okay.
One was passed out hard copy, the others was emailed.
Okay.
Senator Sindor, you're next.
Then go ahead. Yeah.
Okay.
We're good.
So this is Senator Waldstreicher's bill. There are two amendments from the sponsor. So first going over 133521. This was the amendment that was introduced at a previous voting session, which makes it clear that financial institutions are not covered by the bill. And then if you want to turn to the other amendment, which is 753326, this bill, this amendment does a few things. So the main thing is it strikes the term vulnerable adult from the bill to avoid conflicting with other areas of the law, and it replaces it with susceptible adults, and it uses the same definition that the bill had previously used for vulnerable adult. And then it also adds older adults as being covered by the bill, and that is individuals who are 68. Excuse me. Yes, individuals who are 68 and older are also covered by the bill. Additionally, the bill, it pulls in the commercial law statute, which deals, commercial law incorporation and association statute, which is existing law that authorizes the commission to bring certain civil actions, and therefore it authorizes the commissioner to bring a civil action for damages on behalf of a susceptible adult or older adult who is authorized to bring in a cause of action under the bill. And then if the commissioner prevails in an action brought under this paragraph, the commissioner may recover the cost of the action for the use of the office of the Attorney General.
Just a quick question on that. So that last part you just went over, that's pretty unusual. I mean, I like this bill, but the Attorney General can recover his costs for...
In the bill before. If you look at current law on this, so it's not numbered. So
I'm looking at the reprint, right?
11-209. If you look at
What page are you on? I'm sorry, the
it's
reprint.
unnumbered. It's after the unnumbered page after page 2.
After page 2?
Yes.
Okay, I was looking at we're on 327, right?
Yes.
And I'm looking at the reprint for
So it's-
5.
It's Amendment 753326.
Oh, I'm sorry, 7, okay. Go to that one. All right, you're on page 2, you said?
The unnumbered page after page 2.
Okay, gotcha, I'm there.
Yeah, so under current law, the commissioner may bring a action for damages against a person that violates a certain criminal law article on behalf of the victim of the violator or the victim's deceased, the victim's estate. Recover damages under this subsection for property
Okay.
loss or damage. And then what's important there is what's currently A3 under current law. That states that if the commissioner prevails, that the commissioner can recover costs for the action for the AGs. It's like it's just the new amendment language is just mirroring that.
Okay, it's already there. I'm surprised, but there it is.
Thank you, Mr. Chair. I would move the amendments.
Was that, all right, you got me on the second before I raised my hand, sorry. Really quickly, just a couple questions. Is there another place in the law, and if so, where we define susceptible adult? Where did that come from?
So there are other places in the criminal law where we establish a definition for vulnerable adult. And so as this bill came in, it had, in this context, a different definition for vulnerable adult than we do in the criminal law. And the advocates behind the bill realized that this could cause confusion, that vulnerable adult is defined differently in different parts of the code. And so they wanted to separate that, and they did it simply semantically. So they changed in this bill vulnerable adult to susceptible adult in order to keep their definition of what that meant and allow that to be separated from the criminal law of abuse of vulnerable adult. And so that's how that distinction got made.
So I understand the intent. I just have a bit of a concern about the use of that language. I mean, arguably, any victim of any fraud scheme or theft scheme or anything is a susceptible person because they were drawn into whatever it was, or they were victimized. And so if we don't already use it in the law, I'm concerned about using it as a first time in only this bill. And I understand the intent of the bill. I actually support the bill. I just think this is, it's a matter of concern for me, because then are we just going to start in other places saying susceptible victim, susceptible child, susceptible adult, susceptible teen? Do you know what I'm saying? It's just, it's strange to me.
Yeah, I mean, I hear what you're saying. It's always challenging when you are making new law. But of course, that's what we're here to do. The intent of this bill is to better protect people who are older and who are taken advantage of, oftentimes by their own family members. It's not designed to protect people who are just gullible and, and answer the email from the prince from Namibia. This is specifically designed for certain circumstances. And so I wouldn't want to go down the road of trying to define other susceptible adults, or in your example, just kind of regular old gullible adults. We want to keep this narrow and specific to the population that we're targeting and the problem that we've seen in all of our communities.
I understand. I'm not sure that I agree, just because I think it's just under different circumstances, different people are susceptible to different schemes. Someone that's 40 years old who's just experienced a tragic loss under those circumstances is likely susceptible to being taken advantage of because of their emotional state. I mean, it is just, to me, a troubling term. I'm not arguing against the bill or the amendment. I just have to point it out because it's troubling. The other question, because I apologize, because I was a little distracted when you first got on this. So we are or we are not leaving in the financial institution. We're exempting financial institution from any responsibility, no matter what their role in such a scheme would be?
Walstringer?
Yep. So we're not exempting the specific actor at the financial institution who may have been responsible for this. We are exempting financial institutions as a whole because that is not the behavior we're trying to grasp within this bill. I share your concerns about what happened in California. As you know, Wells Fargo opened up checking accounts in the name of people who did not request those checking accounts, and that is problematic. That can be handled in a different bill. That is fraud by a financial institution. The people for whom those checking accounts were opened were not just vulnerable adults or susceptible adults. It was a lot of different people and customers in the bank. So I'm with you. I'm happy to address that behavior in another bill, but it's not the right place to be addressed in this bill.
The concern I have is by specifically exempting them from accountability under the bill, I'm concerned, and it may be addressed, but you can answer it, that, you know, the ordinary negligence that they would be accountable for under any other civil liability petition claim would also be exempted. For instance, right now, forget this bill, someone steals my checkbook and goes around and writes 50 bad checks, and the bank fails to catch that, I have ostensibly a claim against the bank. I would not want that to be something that we would not include here, where someone's being taken advantage of. At some point, the bank, the financial institution, has some responsibility in catching that and stopping it, and they should be held accountable if they don't.
That's right. No, you're absolutely right. This bill does not change current law in terms of the responsibility under the hypo that you've offered. So under the hypo that you've offered, someone could still have a negligence claim, a fraud claim against the bank. This bill only writes them out with regards to this specific civil claim when it comes to susceptible older adults and protecting their assets from fraud. And so the claim against the bank is still valid in the examples that you're using.
But how so if I'm 69 and disabled in some way, or, you know, beginning to have early Alzheimer's, and my children commit fraud against me, and the bank does not stop it. The bank has some responsibility. I'm concerned if we take them out under this bill, whereas if I'm 40, they're accountable. But because it's part of a scheme and I'm susceptible, maybe they wouldn't be. And that's my concern.
Yeah, they still would be under a negligence claim. This bill does not bar negligence claims at all. As you know, I want to make sure people have access to justice, can get into court, plaintiffs can be heard. This bill doesn't change negligence claims. It simply does not provide a new cause of action against the banks under this bill.
Okay.
All right, so go ahead, and then do you want to move, did you move the amendment? I did. Okay. Did we adopt that?
No.
So second that, I seconded it, and then is everyone okay adopting the amendments? Okay, great. Go ahead, Heather.
This is a point to Senator Carter. If you look at page 7 of the bill, beginning on line 15 through the unnumbered line above line 19, it's a cause of action authorized under this subtitle is in addition to and cumulative with any other criminal or administrative claims, causes of action at law, or in equity or remedies otherwise available to the susceptible adult or older adult, including an action under a certain article in the commercial, a certain section of the commercial law and corporations and associations article. So that goes to what Senator Waldstreicher was saying.
All right, now the bill's before you is amended. Any other further discussion? Sure. Senator Lee would like to be amended on. Further questions, discussion? All right, is there a motion? Seconded. All right. Everyone okay, or is everyone, you want to do roll call, or is everyone good? Senator West and Senator Hedelman amended on as well. Senator Jackson. All right, excellent. So the bill passes as amended unanimously. All right, we're going to go on to Senator Sidnor with Senate Bill 335.
This bill requires a non-government corporate party to file certain disclosure statements and to update the statement as required if the required information changes. There is an amendment in your packet. The amendment strikes subsection A, which had previously stated that the bill should be interpreted in a manner that is consistent with the federal rules of civil procedure. And then it also made a technical change on page 2 of the bill about the number of copies of the disclosure statement that need to be filed. And then page 2 of the bill goes over the contents of the disclosure statement, which would require the non-government corporate party to specify, they would need to identify any parent corporation and any publicly held corporation owning 10% or more of its stock, members or owners in a joint venture or limited liability corporation, partners in a partnership or limited liability partnership, and lastly, any corporate member if the party is any other any corporate member if the party is any other unincorporated association.
Thank you. And if I may, the amendments that you have in front of you were put forth to address the memorandum from the Maryland Judicial Conference, who opposed the initial bill as drafted. So by striking the language on the first page and modifying it from 2 copies to 1, I think we addressed their concerns and would move favorable for the bill as amended.
So Senator, I know where you're coming. I'm not sure why we don't require this already for a lot of the circuit court cases where you're suing for $100,000 and all and up. My only concern with this is that this would apply to every little district court action. I mean, any business collection, if the suit's for $3,000, you'd have to file this big corporate disclosure that nobody really cares about. I mean, it's a $3,000 case because you didn't pay the local hardware store that's incorporated, and they'd have to file all this extra paper every time they go to collect on a small debt. And in the federal court, you have the original. I don't even know what the minimum jurisdiction is anymore. Senator Wallstreicher lives in that venue more so, but it would just seem to me that this bill would be better if we said that in any action, say above 100,000 or whatever the threshold jurisdiction is currently in the federal court, to match that, just to not have people filing all this extra paperwork just in every little collection, district court, small claims action, everything else across the state.
Thank you. I hear you, but I certainly would push back because, again, this is about transparency and making certain that not only the public knows who's using their courts, but it's also about ensuring that our judges have the information that they need. And if I might point out, in the written testimony from the Consumer Law Center, and I'm going to quote from that testimony, says, one court has explained the purpose of the federal disclosure requirements as follows. Corporate disclosure statements exist to assist district judges in determining whether they might have a financial interest in a corporate entity that is related to a corporate party in a case before them and therefore requires their recusal. So this is something that I think is beneficial to not only to the public but to those judges, and those reasons that one might recuse themselves can happen in cases above 100,000 as well as below 100,000. Thank you.
And I fully support the federal law on this. It's just that in the federal jurisdictions, you have corporations coming in that may be publicly traded. I mean, a judge may not even know they have an interest in that corporation, and so they've got to make these disclosures because a judge could find out, in the middle of the lawsuit, they'd have no idea that they were invested in that. But in your run-of-the-mill district court action with every little LLC, every little corporation that are typically, 1 or 2 people, family-owned, individual owning a corporation, it's going to be so obvious in these small claims actions who's where, and a conflict of interest is just not going to arise like you would see in the federal courts where it's just tough to see whose business relation is with what. And typically, your local folks know who owns what, who's invested in what. This is just going to be one more unnecessary filing. So I thank you.
Thank you, Mr. Chair. Well, the history of this is way back in the late 1960s, President Nixon nominated Clement Haynsworth to the Supreme Court. And a lot of research was done into his holdings, and it was discovered that a case in which he'd participated had parties involved in the case, and one of them was indirectly related to a publicly traded stock. So because he lost the nomination and went down as a result. So the Fourth Circuit adopted rules shortly after that, which required these sorts of disclosures to be made to avoid another situation like that arising. And then all the other circuits adopted the same rules. So that's how this came about. It's to enable judges to carefully weed out cases in which there's a conflict. I'm sensitive to what Senator Castley says, but it does seem to me that, especially if you're a company that goes into court with any frequency, you simply could prepare a disclosure, and whenever you go into court, you file the same disclosure. It's not like you've got to do a lot of work every time you go to court. You just pull it out and attach it to your pleading. So I don't think it's terribly onerous on the part of the companies, and I think it's probably a good idea.
Motion?
Yeah, can I get a second?
There you go. Well. All right. That's all. No, we've already adopted the amendments. That was on the bill or the amendment? It's the amendment. Sorry, the amendments are adopted.
All right.
All right. Further discussion. Is there a motion?
So moved.
Seconded. Do you want to do a roll call? Let's do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
Bill passes.
Josh, we're going to go on to Senate Bill 202.
This bill increases the amount of time that an inmate who has been sentenced to life imprisonment after being convicted of a crime committed on or after October 1st, 2021, must serve before being eligible for parole consideration from 15 to 20 years, or its equivalent considering allowances for diminution credits. The bill also eliminates a requirement that the parole of a person serving a parole-eligible life sentence in a state correctional facility or the Patuxent institution, subject to the recommendation by the Parole Commission or the Board of Review, be approved by the governor. You should have 3 amendments in your packet. The first is number 723326/1. This further increases the time that an inmate must serve before being eligible for parole to 25 years. Amendment 263424/1 also includes the same increase and additionally eliminates diminution credits from the calculation of that time. And finally, amendment number 653525/1 requires the full parole commission to review any inmate who has been sentenced to life imprisonment and requires 7 affirmative votes from the commission to approve parole for such an individual.
Obviously, everyone knows what the bill does. We're in receipt of 3 amendments. We'll discuss the amendments, and then we'll move forward. So, discussion on the bill first. All right, Senator Ruff.
I'll just say, I would like to, if there was a way to do a compromise on this, because I've long time been very actually sympathetic to this bill, and just to go, I think the whole time I've been down here, and probably the whole time my other colleagues have been here longer than me, this bill's been down here. And I remember the first reform we did, I was sympathetic because I remember when I came in, Governor O'Malley was blanket not granting any of these. And I found I thought that was very unfair because people were getting a sentence that said with possibility of parole. And you had O'Malley and Glendenning had done it before where they just said, no, I'm not doing it. And I said, well, that's not a fair system because you're stuck at the whim of politics. If you're serving your time during a time when you have a governor that just blanket doesn't want to do these, then you can't get out. So the first reform we did was O'Malley literally would not give an answer one way or another. So we did a bill, we passed it out of the House. I believe it passed by one vote after like 2 or 3 days. And, I guess any of us who voted for it were the deciding vote, but I was the only Republican that voted for it, and a bunch of Democrats voted against it. It barely passed, and that was just to say you had to do an amendment or to make a decision one way or another. So I think that was actually a very small step, but I would like to support the bill, but I have two concerns. One being that currently under law, the way that the parole board does it, and this is a big step, you're removing the governor, which is a check, and I can intellectually agree with why we should remove the governor, because there has been, it's not at this governor. I think this governor has been fair, he has done them, but we've had governors in the past that haven't. And quite frankly, I actually went to a talk on this, and Glendenning and Ehrlich both told me, they're like, governors want to be out of this. You don't want this on you. So you're actually doing the governor a favor by removing him. But I think it's a fair system, but right now the way the parole board votes, they only take, and correct me if I'm wrong because I don't have it in front of me, but they only vote to take up the case. So they go look at one of these, 2 parole board, or 2 members go out. There's 10 members on there. Only 2 go out. And if they can't vote it, the 2 of them agree, then they bring in a 3rd. So the decision is only made of 3 of the 10. And so if you're removing the governor from the system, what we'd always talked about before was requiring the full board to look at this, and the full board to vote and make a recommendation. My understanding is there's not even a quorum requirement right now on the board. So it should be 10, and I thought it was fair to say a supermajority. That's still 7. That still means you have 3 people dissenting. But you've removed the governor, and so therefore, that's, you've changed the system. And then the last amendment I would bring up, because this has been a bill that's also floated around, the idea for years was we were always going to merge these together, was that second-degree murder, you are eligible at 20 years. Right now under Maryland law, you are eligible earlier on a first degree than you are on a second degree, which doesn't make any sense. So we have for years talked about making first degree 25. And so we hadn't done it for whatever reason. And a lot of it was we were going to merge these 2 bills together and put it out. I have not talked to the sponsor, but I know in the past the sponsor was open to these amendments. She wanted to move the bill. So that's my case for it. I think that, these are common sense amendments that I'm offering that would improve the bill. I would like to vote for the bill, but I don't feel comfortable voting for removing a check and balance of the governor to going to only 2 or 3 members of a 10 board voting to do this. I think that in itself is a problem, and I think we should at least do 25. That's a positive for the families too, because the biggest thing it does, it's not that they're not going to get out on the first one, but what it does is it drags the families in and the victims in to go to an unnecessary hearing. So the 25 is really to help the victims and the families who, let's face it, are going to be upset that we're doing this. And I was told, I talked to the governor's office, every time he makes a decision to release somebody, the victims' families, they all call in upset and distraught. And so it's not a simple bill, but intellectually, I understand it, and I've always been supportive of it if we can do it the right way.
Sure. I want to make sure just that folks, I think, what you said overall, I mean, it makes sense, but let's take them one by one first, because I think there's confusion of how the process works, but I want to make sure members get a chance to chat. But before we do that, let's just kind of do some stage setting so we understand the process. So, and Josh, please chime in and correct where I veer off. Now, initially, when Senator Huff referred to sections 7-3-307 of the Correctional Services article, Now, that laid out the process of an initial review goes to 2 commissioners. If they can't approve the decision unanimously, then it would go to 3, in which 2 of the 3 would have to approve. And the way that the code is drafted, it leads you to believe that that would be kind of the end-all, be-all of that process. When in fact, if you look into the regs, there's additional processes that are actually in play here that are not nested in the code. And so just don't trust me on this. I'll have Josh kind of pull up the sections of COMAR that are relevant to this. But the process that works is you get someone, you got to have 15 years, depending on your sentence, or longer. And then I've got my drawing here, my rendering here of the process. You've got that parole hearing with that 1 or 2 or 3 commissioners. That then leads to 3 decision points. You could have a risk assessment, a rehearing, or a denial, right? And then each one, and this process takes also, and this is not like a very quick process, it's a very slow, deliberative process, it takes years to go through. So the risk assessment, DOC evaluates the person's suitability for a recommendation. You also have an option for a hearing with a commissioner for review. There's 2 original commissioners. They'll review the risk assessment. Then there's an en banc option. I mean, I'll send this to you all to show how complicated and layered the process is. The point is this. After you go through that, it has to go to all 10 members. And then a majority of those 10 members have to make that recommendation. So it's not as if those 3 members are responsible for making the recommendation for release. There's like another process that's nested within this, and it takes years to go through, and there's several layers of vetting. And so I think that argues against plussing up to a supermajority when you already have all of these layers and all of this time and all of these decision points, and then you have a simple majority. 6 of the 10 have to decide. So I just want to,
It actually states 6 of the 10.
yeah, it's a majority. So majority.
No, majority
Let's get clarification on that. But I just want to make sure, because initially, just by reading the code, you would come away with a different conclusion of the process. But go ahead.
So this is COMAR section 12.08.01.17.7F. So a parole release hearing for a prisoner serving a sentence of life imprisonment shall be conducted by a panel of 2 commissioners, and if they agree to recommend the granting of parole, the case shall be presented by the panel to the commission en banc. If the commission meeting en banc agrees that the prisoner should be granted parole, the commission's recommendation for parole shall be forwarded to the governor. So it doesn't explicitly state what vote you need. I think the practice is majority if the phrasing is the commission agrees.
I was going to say, I talked to the parole board about this, and there is not a quorum requirement. And so I have concern about. I talked to the parole board about this, and there's not a quorum requirement to their meetings now. And I just think we are going from this huge check and balance of having the governor there, an elected official to oversee, to going to the parole board, which I can intellectually go with, but we need to have it laid out in law, not just COMAR, exactly how this works. And I would say in these cases, look, mine was, it moves it from 6 to 7, but even right now, they do not have an actual quorum requirement. They're not like us, where they have Robert's, maybe they operate under Robert's rules, but I have no idea what they do. So because they don't have a quorum requirement, a majority could be 5 people show up and 3 vote it. It's silent on that. And so if we're going to go to a step to remove the governor from the parole process, we had better have in law exactly how that process works, so we can go back and tell people and have assurance that it works properly.
Josh, all right, go ahead. I want to go to Senator Castle, then back to Josh. I had a question for you as well.
So just speaking on the bill for a second itself, and here's something that troubles me greatly, is that when I look in the bottom of page 1 and on the top of page 2, if you're somebody who's already in the DOC, you're doing time on a life sentence, you would serve 15 or the equivalent, which if you get dim credits, what are you, down to like 9 or 8 or 9, 8 or 9 years or less, possibly much less than that, then you go to the parole board and you can get out based solely upon the parole board. And I find you're now parole eligible, and you'll keep coming up, and you'll to be in that position. Actually, you've only, I mean, a life sentence. I mean, they don't hand out life sentences too easily. You had to do something really, really bad, and at some point, I got it that you totally regret what you did. I got it that you've been a model prisoner, but to say that maybe you could only serve like 8 years on a life sentence because you intentionally killed somebody just seems like a ludicrous thing. And the parole commission's job isn't to say, did we extract our punishment? Their job is to say, can we safely release that person? You may be able to safely release them and feel confident in that, but the idea that the punishment for first-degree murder might be as little as 6 or 7 or 8 or 9 years in prison is just ludicrous. And so I think it's important, you know, they have it in 15 years, but they knew the governor was going to be on top of this. Well, we're taking the governor off. So now it comes back to us, not the governor, because no governor would ever say, oh, you can have a first-degree murderer can get out in 10 years. No governor would do that from either party. We're pulling them off now. So if we're going to pull the governor off, it's up. We need to state what that policy is. And if our policy is going to be, hey, bottom line, you're going to do X number of years for first-degree murder, it should say that right in here, parole commission. Don't even start looking yet until they've done X number of years in the DOC. Forget dim credits. Here is the actual, no kidding, punishment for first-degree murder. It'll say that in here. And obviously that's I see Senator Huff has a proposal, but I think it's just essential that we state in here, because the way it's written right now with this amendments is our stated policy on punishment could be, and I'll leave it up to council to tell us what you could get on dim credits, but I'm assuming you're down to like 8 years or so. If you serve 15 and you apply dim credits, how far down could you go, council?
I think it's more like 13 or 14, but I have to double check that.
Okay. In any event, none of that's an appropriate punishment for first-degree murder, and the way with this amendment and they're sort of. You have to really reflect on what's the impact on the first part of this bill with the governor out, because with the governor in, we all knew what the policy was going to be, but that's gone. So now we got to say, here's the policy, and I don't think anything like 13 years for first-degree murder is an appropriate punishment, and we can't expect the parole commission. Their job is not to say what the punishment is. Their job is to say, can I let this person go safely? But there's the other half, right? In any sentence, you have two aspects of any sentence. You got the part that's for the community. Here's the punishment, and you have the part for the perpetrator, where you say, I'm going to try to turn your life around. And this is the parole commission's only focused on that part about turning your life around. We've got to say the first part. Here's the no kidding punishment. Thank you.
You have Senator Sidnor, you're up, and then we'll go over to Senator Huff.
No, you made my point. I'm fine now.
Just the last point, if we pass it as is, 20 years with dim credits, not only is it 13 or 14 years, it's the same penalty as second-degree murder. I mean, that's really bad lawmaking, that first-degree murder should have a higher penalty that you serve versus second-degree. So, I mean, this is just, you're going to take people who are first-degree murder and first-degree rape, and you're going to make them eligible 13 or 14 years, the same as the second degree. I mean, the idea, if we're going to have these penalties, you should get more for a premeditated murder than you do a second. So if we pass this as is, yeah, you're removing the governor, and they're going to be eligible the same time as the second degree murder or first degree murder will be. That's just not good policy.
No, I know I realize there's an incongruity that was established there when we went through the JRA process, which I guess that happened, I don't know, 3 years ago. But the bill also, so right now you're eligible at 15 earliest. The bill does move that up to 20. So I think that's part of the concession there. It's bumping it up to 20.
It's the same as second. That's no concession. Second-degree murder is 20. There's no concession here.
Right now, that sentence though, you get your first look at 15, and it's bumping up to 20.
I think this is way overboard. I know the advocates want it clean. I think that the amendments I'm offering are very reasonable. So I'd like to offer both my amendments. I'd like to start first with the parole board. I'd like to offer that amendment, and I'd like to vote on both the amendments.
So we'll take them one by one. Which one do you want to offer first?
I'll offer the parole board one first.
So the parole board, that's bumping it up to from 7 to 6.
Yes.
Supermajority. Also,
Well-
just real quick, before we take the vote, I want to get
Sure.
clarity on the quorum piece. So in Comar, that is outlined in Comar, yes and no, council, and could you tell us?
In Comar is if the commission meeting en banc agrees that the prisoner should be granted parole. So it's not made explicit what that requires.
So it's not. So I don't just understand. So there is no quorum requirement, correct?
Not in Comar. I don't know what
I
they're.
mean, I called the parole board and I talked to them about this, and they told me that too.
Thanks. I too was combing, looking for specific language, and I haven't yet found it. But I would just submit that in other situations, we have review processes, not with the parole board, but for example, with criminal convictions in circuit court, we allow for a review, an en banc review by a 3-judge panel. And in that situation, it's presumed that the 3 judges would be there and that a majority, the 2 of 3, makes the decision. More often than not, it's all 3. I don't even think I've ever seen a situation when it was not unanimous one way or the other. When it comes to the Court of Special Appeals and we have the review panel, it's 3 judges, and 2 of the 3 make the decision. So I just don't know that I would speak against the concept of a supermajority where we don't require it. Even with our Maryland Court of Appeals, it's a majority of the judges that make the decision. And we don't say, well, we got to make sure they're all sitting there. We know that it's got to be a majority decision in order for it to have weight. So I would argue against the idea of a supermajority being required. And I would also think that a majority of the parole commissioners sitting in banc would speak for itself in the absence of being able to find specific language, which I'm still looking for. Thank you.
Yes.
Yeah, I don't really consider Senator Huff's proposal for the classic supermajority. I mean, he's actually asking for a quorum of, he wants the full board to be, to register in and a vote of the majority of the full board, which isn't really what I think is of a supermajority. It's a vote of the full board. And the Court of Appeals, you're going to get a vote by at least, well, you're going to get a vote out of all 7. They'll bring somebody else in if there's a conflict. So you're going to get 7. Court of Appeals, you have the right to go for an en banc if you want to petition for that. Of course, their jurisdiction is limited in certain matters. So I'm not sure that's a really good example either. I think to have more people weighing in on this is important when you're pulling. I mean, this isn't like these are decisions you make every day. I hope you're getting paid to be on that position, and it's a serious enough matter that everybody ought to all show up. I mean, I got it that you can't hold the decisions up because one person is very, very seriously ill and they'll never be there, but you could certainly require that they take these seriously and not try to duck out for political purposes and that kind of nonsense.
So council, you have a citation, Josh. Just the citation that you have there for what an en banc consideration, what that process looks like. Could you read that? It says a majority of all members then serving on the commission shall constitute an en banc panel. The members of the panel and no others shall vote relative to the parole revocation. Members may abstain from voting only in the event of a conflict of interest. The decision of the commission shall be the majority vote of all the members serving on the panel.
Yeah, that's absolutely correct. That's I think it's 12.08.01.23. I think that is.
So just to be crystal clear, majority
Yes,
of the members on the commission unless there's a conflict of interest.
correct.
We have this fight all the time in our local delegation that we had to say it requires 5 votes to get out because there's 8 members. And what happens if only 6 show up at the meeting? You have a majority of the delegation there. So it would have taken our delegation, it would take 4 members then would be a majority of the 6. So you just knocked it down. So we required that it be 5 stated. And with what you're saying, it's the same thing. It doesn't say you have to have 10 there, it just says you have to have a majority.
The majority of the members then serving on the commission, so
So it could be 6 people show up and 4 could vote to do this.
then serving, if all are impaneled, if you have 6 members impaneled, or
Yeah.
8 members impaneled,
And furthermore, we shouldn't leave this in Comar. This
But
is a
you're-
big deal. We have been debating this for probably 20 years. We should put into statute what we actually want to do. And my reading of that with Comar is 6 members, 4 can straight up vote to do this. And only remember, the only ones that actually really heard it and did it could be as low as 2. You could have 2 members that started the process, heard it, did the work, take it to a board, you only have 6 show up, so 4 now vote. So we have removed the governor from the process, and you could have a situation where 4 do it. And by the way, it's all left in Comar. So if they want to change all this and make it even worse, we don't have any say over that.
Thank you. So, just in listening to what you're arguing, I'm wondering if we were to take what's in Comar, put it into statute, as to it's the majority of the people who, I guess, you don't want it being the majority of the folks sitting on the panel, but you want the majority of. Would you be comfortable with the majority of the people who are on the commission? So then it's at 6 rather than.
I want all 10 members there to vote on it, all 10. And even offering 7 is a consensus because other people want a unanimous vote on there because you remove the governor. So I want all 10 to be there and present. And my amendment right now is to say 7 should vote in favor of it, which would be higher than what we presume would be 6. Because we're presuming it's 6, but as I said, I think it's reading the Comar interpretation and having been through this in our delegation, it's as low as 4 right now.
All right, I'm trying to see if there's some ground there because I'm the amendment as it is. I'm certainly not in favor of it. But
Which part of
I
it
believe
are you?
I hear what you're.
Which part are you not in favor of?
I don't like the supermajority. I think a majority is fine.
So if you did 10 and required 6, are you in favor of that?
I mean that's how I'm reading that's how I'm reading the Comar.
I mean, I'd like to find some consensus here.
So, look, I know the recent history is that there are very few months or years in which there wasn't a full panel or full commission impaneled. 8 of the 10 are Hogan appointees, which I assume would remain. I don't know. The last 2 are holdovers from prior administrations, but I don't know how long that will last. Who knows how long they'll serve? But go ahead, Senator Castley.
I think the strongest point that's been made that I think both Senators Huff and Sidnor agree on is the taking it from Comar. We don't control Comar. I mean, we can indirectly through the ALR process, but we don't really control Comar. And so on a matter like this, I mean, in Comar, we give the bureaucrats discretion to change it unless we come back and enact a conflicting law. But on a matter as important as this, I think Senator Sidnor has the right sense on it that let's take the Comar language, and if you've got 10 people on the board, and it has to be a majority of those people, of the majority of the 10 has to vote in favor of this, I think that's what we're really looking for.
So how about this? I'll withdraw my amendment, and I'm offer substitute. It says 10 members have to be present, and it's requiring a vote of 6. So I offer that as an amendment.
Look, I don't think anyone's opposed to that general idea, but what if 10 members aren't impaneled?
You mean like somebody died and you want like?
Yeah, like, or no, because, exactly right. I mean, like, the appointment, they're going through the appointment process, change administration. I mean, what if 10 members aren't
But
impaneled?
So the number of 6 would still stand firm. You'd still have to have, I mean, so instead of getting 6 out of 10, you get 6 out of 9. If 2 died, you get 6 out of 7. I mean, to say 6 people have to support this, I don't think is too onerous. And we can go all the way down to 4 people dying before we lose the 6. That would be a pretty bad year.
I mean, to me, in keeping with the spirit of what's in Comar, would be the majority of the members impaneled. But then you get down to, I mean, I know what you're saying. I know you get down.
You're removing the governor. You're going down to potentially 4.
I just. Anyway,
It's getting
Go ahead.
really close.
go ahead, Bailey wants.
That's a pretty reasonable issue with the 6, no matter how, and I'd go ahead and second it.
To speak on it, and then
I agree with the 6. I mean, we're talking about letting first-degree murderers out of jail. If we take the governor out of the process, and I agree with the words that have been said here, that some of the governors have been irresponsible and simply say, I won't consider paroling anybody. But once we take him out of the process, then we have to have mechanisms here to make sure that if we're going to let first-degree murderers out of jail, there's a strong reason to do it. So.
I just keep going back to the point of if there's situations in which the full panel isn't there. I mean, they're not impaneled. So I mean, then you've switched the majority situation to a supermajority or more or worse.
So, Will, if it's in between administrations and they haven't filled positions, so the murderer has to wait an extra 6 months or a year or 18 months until the panel is full to get the vote of 6. I don't have a problem with that. I'd rather have the delay and make sure the decision is right when we're talking about first-degree murderers when the decision is made.
I guess just that is compounded on top of this already very arduous process where vetting has gone through. That's I'm very uncomfortable with having a hard number when you don't have the members. You don't know that all 10 members would be there. I just think that after all of this, I mean, this is a very no one gets this. No one gets. I mean, it's just a first look. Just very uncomfortable with that. Because if you have that number enshrined, and there aren't 10 members there, let's say there are 8 members, let's say there are 6 members.
Yeah, but.
Well, that's what I was saying. That's
what
more
he's
in
saying.
line.
But
That's what I think it's more in line with Comar.
I mean, how often do we have a situation where we don't have 10 members? I mean, obviously somebody dies and you have 9. I get that, but the governor's going to move on an appointment, whether we're in session or not. They'll move on an appointment. I just can't envision periods of time where you're going to have this commission down 2 or 3 members, and to say you have to have 6 out of 9 or 6 out of 10, I mean, seems like a fair number of people for given the gravity of the situation.
Everyone understands it to be that if we hadn't gotten this whole discussion, everyone would have assumed in this room that the 10 sit there and 6 the majority are going to vote for it. It's what everyone would have assumed. It's only when you dig into the law and you start to figure out it's only 2 that actually hear these things. Remember, the people actually hearing it, investigating it, are only 2 of them. And so, like I said, I just think we should move the amendment. I mean, to remove the governor is a huge step. Huge step. And we should at least require 6 members of the parole board and everyone to be there to do it. The parole board hardly ever has vacancies. That is like the most sought after board to be on in the state. That's not a problem.
You talk about 2 people doing it, but I can't imagine that those 2 people or 3 people, whoever it is, aren't coming back because the full board then does need to vote without an extensive, document or something that recommends, right? Is that right?
So my understanding is that it is a lengthy report that's produced,
right.
but it's not like a new hearing or anything. So
right.
it's like they'll present their facts and findings in a brief.
With the assessments.
Correct. All the entire criminal files in there, everything's all there before the consideration, but it's not another hearing It's not like the incarcerated person's going to be there to make a presentation.
Right, but still, these are 10 people who have to make a very, very serious discussion, and I assume, giving them all the due of, that they take their job seriously, that they're going to review the documents quite extensively. So it's more than 2 people who are, my point is, it's not just 2 people who are looking at this, it is the full board.
Just a couple of questions on this chart. This is the chart that was just handed out on our desk. So I just want to, the first box, it says at least parole eligibility, at least 15 years. But that's not true, because we just looked in the first line of this bill, who was served 15 years or the equivalent of 15 years. So it's not 15 years, it's 15 minus dim credits. I'm sorry?
The bill bumps it to 20.
Well, wait, that's only for people, that's prospectively.
Yeah.
Not for all the people that are currently in there. For the people currently in there, it left it at 15 minus dim credits. And so that's not a negligible number of people to be considered here. That's a lot of folks who would be down to 15 minus dim credits. And I think that's you're looking at half the bill for cases that people haven't been murdered yet. And I'm talking about everything that's currently in the system. So that, and then on the third row of boxes, it says denial. The person has no future possibility of parole. Is that true? That if my very first trip to the parole board, and I really flub it, I say all the wrong things, I'm nervous, and they say, "What a jerk! You're denied," and now I'm forever. I can never come back to the parole board again. Is that?
But that's my understanding. But go ahead. I'll give it to counsel to.
I mean, I hope we're not quite that rigid.
Yeah, I honestly couldn't tell you how often that happens. I don't really know. Yeah, I believe that it's something they can do, yes.
They can, so I've been in for 20 years, I come up for my very first hearing, I blow it, and now I can't come back in 10 years or 20 years or 30 years or 40 years or 50 years, no matter what changes. Once that first hearing and I get a denial, then...
Yep. Let me go back and make sure that's correct
Okay.
before I say for certain.
It doesn't make sense to me. Okay, thank you.
And because I think we're really close on this. I honestly, like I said, for years, I wanted to work out something on this. I honestly want to work out something. I think some of us like to work out something. Let me talk to the sponsor of the bill too. And I think there's some compromises here we can work out something. But I would just ask that we just hold this until after we come back from session and we'll vote on it. I'm not trying to delay it, but I honestly think I'd like to have a couple conversations with some people in the committee. I'd like to talk to the sponsor because I think there's room for common ground here.
Senator Sidner, do you want to speak on that?
No, I'm fine.
All right, good. I mean, look, I think the kind of getting the background of all this was really, really helpful for the discussion. So, I mean, we burned 25 minutes on it, but I thought it was a fruitful discussion. So we'll come back. We'll vote this. We'll vote this when we come back from session at noon, after our noon session. All right, we've got 13 minutes left. Yeah, let's do that so folks can get a snack or something like that or whatever. We've got a couple of tough bills, but this is by far the most difficult one we've got coming back. And I think we've made some significant progress on the discussion and understanding. We come back after a session. We could be out of here. I don't want to actually make any promises. We'll knock on wood. Hopefully it's, decent. But all right, so we'll come back right after session. Thank you all.